Okay, we're live on YouTube. We can go on the record. We're on the record in case number 9803, which is captioned the Potomac Edison Company's application for a certificate of public convenience and necessity to construct a 230 kV line on the existing Carroll, Germantown 138 kV transmission line in Carroll County, Maryland. Let's take appearances, starting with the applicant.
Good morning, Your Honor. Christopher Gunderson on behalf of the applicant, and I'd also like to enter the appearances of Susan Schipper, you see next to me, on behalf of the applicant, as well as Jessica Raba, in-house counsel at Potomac Edison, and then also Joseph Curran and Ananya Sinha, who are also counsel in this case.
Good morning, Your Honor. Sandra McLemore, representing the Power Plant Research Program. And I'd also like to enter the appearance of Stephen Tolson.
Good morning, Your Honor. Brock Miller on behalf of the Office of People's Counsel. And I would also like to enter the appearance of Michael Sammartino from the Office of People's Counsel.
And staff. You can enter your appearance, Mr. Dean.
Michael Dean on behalf of staff with Kenny Albert also in the case.
Is his microphone on?
No, Your Honor. The light's not on.
Can you turn your microphone on?
Michael Dean on behalf of staff with Kenny Albert also in the case.
All right. I saw a certificate of publication was filed. Did you want to enter that into the record at this time?
Yes, Your Honor.
Yes, Your Honor, thank you. So at this time, we'd like to move into the record one exhibit consisting of the applicant's certificate of publication for the notice of pre-hearing conference, and that's mail log 322142. And we can enter as one sort of joint exhibit also our certificate of compliance with the landowner notice requirements, which is mail log number 322195, and we would like to mark these compliance certificates as applicant's exhibit number 1. And if there's no objections, we would also ask that applicant's exhibit 1 be moved into the record.
Okay. How about, is it okay with you if we split them up into 1 and 2? Okay.
Yes, Your Honor, we can split them up. Sure.
Good. Okay. Any objections to PE exhibits 1 or 2?
No objection, Your Honor.
No objection.
Okay. PE exhibits 1 and 2 will be entered into the record. Okay, I didn't see any requests to intervene. Counsel, did you see any?
That's correct. Correct, Your Honor.
Okay, and then I did receive your email. Thank you for the proposed procedural schedule. Had a couple questions. I guess first off, the status update on November 10, 2025. What would I be learning on that date?
Yes, certainly, Your Honor. And I'll provide some commentary on that and then turn it to PPRP if they have anything to add. But that status update was requested by PPRP. My understanding is that they are under review of the application and supporting materials. They've asked us a data request regarding information that they want to make sure is contained within the application. And so the status update would be for the purpose of updating the commission as to the company's provision of any additional information that PPRP would like to see included with the application. So we intend to work over the next couple of months to make sure that PPRP has received everything and will provide a status update as to any matters that remain open. I don't know if Counsel for PPRP has anything else to add.
Mr. Gunderson did a good job of summarizing that. We do have a DR route. I can give you an areas of interest if you would like to know some of the areas, but that's pretty much what it's for.
Okay, so there's a possibility that you would be filing a motion to modify the procedural schedule if you didn't get the information you needed.
Yes, Your Honor, in the event that they did not provide the information we believe is important.
Okay, and also the footnote to that the next filing on the same day of Potomac Edison's direct testimony says, this schedule assumes that the company will file supplemental direct testimony on the following topics listed in the delegation order. I was a little confused by the wording. Why wouldn't the direct testimony contain that information?
That's a good question. This was a footnote that was carried over from the negotiations with PPRP as to the schedule. So I think we could amend that footnote to say that the company will file supplemental direct testimony on those topics.
Okay, and actually, I'm going to request, in case there's any confusion, that Potomac Edison file, technically supplement its application with a plan pursuant to COMAR 2079-0401B. And so I'm wondering whether you will have time to do so by the date you have in here of November 10.
Yes, it was our intention, the company's intention to comply with that request of the commission. So yes, I believe we'll be able to comply with that by November 10th.
Okay. And staff, you'll be filing your direct testimony by July 14. Do you know whether you will be addressing grid enhancing technologies in that testimony?
I will check with our witness to ensure that they are.
All right. The next, I see a public comment hearing the week of July 27, 2026. I'd like to hold that virtually, if that's acceptable to the parties.
No objection, Your Honor.
No objection, Your Honor.
No objection.
And the next item you have is a settlement agreement status update, and I wanted to clarify, you don't envision a formal settlement agreement, do you?
I guess we didn't consider it one way or the other. We're open to a formal settlement agreement if the parties want to go that route. But to your point, oftentimes in these cases, it is update that the company does not object to PPRP's or staff's recommended conditions.
Yes, Your Honor. It was more of a status update. It would to see if there's any uncontested issues or if there are any remaining contested issues.
Okay, that's what I presumed, and it looked like it was approximately 15 days from when the public comment hearing would be, so that you'd have your 15 days to file revised recommended license conditions. Is that correct?
Yes, Your Honor.
Okay. But Friday, August 14th, being a Friday, is actually only there are 5 business days between then and when you're proposing a evidentiary hearing, provided there are no contested issues, which is a little quick. If there's no settlement and contested issues remain, you have all parties file rebuttal on the 24th. Is that really all parties, or is that really actually just PE?
Typically, it's just the applicant. However, I think there have been cases where staff has responded to a PPRP piece of testimony, direct testimony, but so we left it open for that reason.
Okay, the reason I ask is, again, it seemed a little quick, so I wanted to make sure, particularly OPC, is sure that they can file rebuttal if that's what they intend to do within that amount of time.
As you pointed out, based on it being Friday and only 5 business days, it is a short turnaround. I feel confident that we can. I mean, given the distance from the direct, I think that we already be working on it, and if some agreement was reached with respect to any contested issues, it might fall out before that, but I think that we would already be working on it prior to that.
Okay, so then it's just me, I guess, that has an issue with a uncontested evidentiary hearing only 5 business days after I learned that there are no contested issues. So I'm thinking I actually like your September date for a contested, for an uncontested. And I really don't want to set a contested hearing date at this time. I think when we learn on August 14th whether it's contested or not, we'll set the contested hearing date. Does that work?
Yes.
Okay, that would be 1 o'clock on Wednesday, September 23rd, since it's a Wednesday, for an uncontested evidentiary hearing. Okay, last item. I mean, I trust you looked this over, but you're giving PE 10 days to respond to all their discovery requests, and then suddenly we speed up to 5. Mr. Miller, is that really what you agreed to?
Your Honor, that I think the cadence follows what's usual. I would be more comfortable with 7, I think, with the initial switch, but, from one set to the other. But.
Ms. McLemore, do you?
I tend to agree that 7 would be preferable, but I was not as involved in the settlement discussions as Mr. Towson was, so with that being understood.
Well, I think the reason it's 5 is because of the quick turnaround to rebuttal and surrebuttal.
That's correct, Your Honor.
If we're changing that, then.
Right. So if you want more time, then you'd have to change those dates. Do you want to take a minute and think about it?
Yes, Your Honor.
Can we, Your
just
Honor?
take-
We'll go off the record for a second.
Thank you, Your Honor.
Apologize for being late, Your Honor. The door wouldn't open on the stairwell.
Yeah, exactly.
All good? To go back on the record?
Yes, Your Honor, please.
Okay, back on the record. Who wants to tell me what you've decided?
We have decided that we would like to go to the 7 business days and then after reply the 5 business days, as is typical in most cases.
So you want 3 dates. You want July 14, and then are you moving the rebuttal and surrebuttal testimony dates based on when the uncontested hearing will be?
No, Your Honor.
Okay, so tell me when you want the 7 days to run.
So this 7 days would run from July 14th to August 24th. And
Okay.
after August 24th, 5 business day turnaround.
Okay, and that gives you enough time to get your testimony in?
If Mr. Gunderson could repeat what he just said, that would be helpful.
Yeah, what I'm suggesting is any discovery that is issued after July 4th, or on or after July 14th would be due within 7 business days. And then any discovery issued on or after August 24th would be due within 5 business days.
So the first date is fine, and then we would still keep surrebuttal filing on September 11th.
Yeah, although I would suggest that I don't think you need to, because the contested evidentiary
right.
hearing is not going to be held on September 23rd.
Right.
So that you could have more time there. We're going to set that date after I confer with everyone after the 14th and the status update is received. But it's certainly going to be after September 23rd.
Your Honor, perhaps a proposal would be on the status update, perhaps then have a proposed schedule for the following if it is contested. That might be an option. I haven't really discussed it with the parties, but that might be an option.
Yeah, if I can just weigh in on that. I mean, not totally opposed to that, but it is just helpful for the company to understand the full schedule so that they can plan for development of the project. So that was the intent behind having the date set out. in the
Yeah, no,
schedule.
I understand, but I think Ms. McLemore is right that there's no need to set those if we haven't set the evidentiary hearing. So what we'll do is we'll put in an initial procedural schedule, and then on August 14th, or the day after, Monday after, we'll set the rest of it. Okay?
Understood.
Does that work for everyone?
Yes.
And so, back to the discovery, I'll figure it out, but I think I have 7 after July 14th, and we'll just leave it open. Okay, anything else? What, you look like you were going to say
I'm just
something.
trying to keep up, Your Honor. Everything's
No, I think we're good. But is there anything else?
No, Your Honor.
Okay. We can go off the record. We're adjourned. Thank you.
Thank you.
Thank you.